Hello viewers, my name is Ben Summers and welcome to episode 3 of Lost Sydney. Today we'll be talking about the notorious Hatpin murders. This is Burren Street, Erskineville, running under the railway line and only a short distance from the nearby Macdonaldtown station. It's central to the story. It's a peaceful street, the only real noise coming from the trains clattering over the railway bridge. In many ways, Burren Street is a typical suburban street and, like its counterparts, holds plenty of secrets. Back in 1892, it was the location of a house occupied by John and Sarah Makin, both pictured. In those days, Burren Street was located in a suburb called Macdonaldtown. John Sidney Makin was born in Dapto on the south coast of New South Wales on the 14th of February 1845, while his wife, Sarah Jane Sutcliffe, was born that same year on the 20th of December on Sussex Street in Sydney. Before John, Sarah had been married to a mariner called Charles Edwards. From this first marriage came a daughter called Minnie. Sarah and John wed on the 27th of August 1871 in a union which produced 10 children, 5 sons and 5 daughters. Before moving to Sydney during 1873, the couple worked as hotel keepers, John Makin holding the licence to operate the Settlers Arms Hotel on Crown and Cura Streets, Wollongong. John Makin held various jobs, working as a drayman for a brewer during 1881, and by 1886 as the driver of a van for a greengrocer. While in this job, he was involved in a dramatic accident. His van struck a 4-year-old child while crossing Elizabeth Street. According to Wikipedia, the child sustained concussion and was left in a precarious position, suggesting serious injury. In 1881, Makin tried his hand at criminality, leading ultimately to his arrest and 3 months in prison. He also worked as a driver for a Mr. R. Bedford of Redfern, beginning in November 1891, though he later left this job unexpectedly after only 6 weeks. He was later injured in an accident, which left him unable to work. As a result of this, the Makins turned to the practice of baby farming, which is further explained in the next chapter. Wanted: kind person take charge of baby. Apply stating terms to 333 Herald Office, King Street. So reads an ad placed by Minnie Davis in the newspaper, which the Makins responded to. Davis's child was among those adopted by the couple. Back in the 1890s, the adoption and fostering of infants and children was poorly regulated, and the laws governing these practices were not strong enough to do their job. It was weaknesses in the law which the Makins cruelly exploited. Having an illegitimate child was considered socially shameful, which made it the usual reason mothers were forced by their families to give up their children. Poverty was another factor. The children were advertised in newspapers. Baby farming involved a person or persons taking custody of an infant or infants in exchange for a fee, on the understanding the child would be cared for. The term baby farming was derogatory, implying poor treatment of the infants. The payments to the adopting parents were either received as a lump sum or given periodically. 2 of the ads the Makins responded to specify that a premium would be paid to whoever took the children, as seen here. Sadly, many of these babies were neglected and died or were straight up murdered. These fates were particularly so for children whose adoption was paid for in lump sums, as baby farmers were more interested in the money. The relatively large amount couldn't meet the long-term costs of caring for the child. Baby farming was a common practice in late Victorian Britain, where the poor were denied the right to access subsistence by the Poor Law Amendment Act of 1834, forcing them into workhouses, and for women forcing them to give up their children. In Australia, benevolent asylums were the closest institutions to the workhouses in Britain. Baby farming also existed in other countries, including Australia, the United States, and New Zealand, though in these 3 countries it wasn't as widespread. Eventually, the passage of tougher legislation stopped this cruel and inhumane practice. Frank Cooney and James Mahoney were hard at work in the backyard of a house on Burren Street on the 11th of October 1892. The Makins had lived in this house for a short period, but had since moved. The men were excavating a trench to install a service pipe between the sewer and the house when Mahoney made a gruesome discovery, which he initially believed were the decomposed remains of a cat. On returning to work the next day, Mahoney discovered the remains of an infant, not far from the other set of remains which he had uncovered the previous day. He and Cooney quickly informed the Newtown police, who took the bodies to the South Sydney morgue. A preliminary inquest held inside the morgue determined the remains to be male and female. Our story next takes us to a vacant lot of land on Zamia Street, Redfern, where on the 14th of October 1892 the remains of a male infant were discovered. The child was estimated to have been 20 days old. Meanwhile, Senior Constable James Joyce found himself on a property on Wells Street, Redfern, where the Makins were living at the time with their children. Casting his keenly trained eye around, the energetic Joyce noticed something odd: a freshly dug patch of earth. His mind buzzing and whirring as he processed the scene, Joyce's suspicions were aroused, and he ordered the patch dug up. Though no remains were uncovered under the dirt, the police concluded that the body found on Zamia Street had been originally buried at Wells Street before being disinterred and reburied at the new location. The inquest was moved to the State Coroner's Court at Chancery Square, resuming on the 26th of October 1892. A number of witnesses were called to testify, including Frank Cooney and James Mahoney, several neighbours of the Makins, the doctors who had performed the autopsies, Senior Constable Joyce, as well as the government analyst. The cause of death couldn't be determined due to how decomposed the remains were, and the inquest returned an open verdict of found dead. By this time, the Makins were living on Chippen Street, Chippendale. Senior Constable Joyce travelled to their new address on the 3rd of November 1892, where he subsequently placed John Makin and his daughters, Blanche and Florence, under arrest. They were taken to Newtown Police Station, pictured, where they joined Sarah Makin, who had been arrested in Parramatta. It was at Newtown Police Station that Blanche Makin told police she remembered her mother saying she had 3 infants to care for at one time. Blanche Makin also stated her parents had instructed her to deny knowledge of the other infants they were caring for. This statement contradicted her evidence at the earlier inquest, where she had said her mother had only looked after one child. John and Sarah Makin were consequently charged on suspicion with causing the death of an illegitimate female child, the offspring of Horace Bothamley and Minnie Davis, on or about the end of July or the beginning of August last. Their daughters, Blanche and Florence, were also charged on suspicion of being concerned in the death of the child in question. 2-year-old Cecil, the Makins' youngest child, went into the care of a neighbour. Come the middle of November 1892, and yards in East, Kettle and Botany Streets in Redfern had been excavated with no luck. Howard Street and Bullenaming Street in St. Peter's were searched as well. Between the 12th of October and the 12th of November, a total of 15 bodies were recovered. These led to inquests, some of which returned open verdicts. By this stage of the investigation, Senior Constable Joyce had formed the view that the Makins engaged in baby farming and had ended the lives of the children supposedly in their care. The exact cause of these deaths was never determined, though based on the bloodstains on their clothes, the infants were believed to have been stabbed in their hearts by way of a large needle, thus giving rise to the Hatpin Murders name. It is worth noting that a family matching the description of the Makins had moved out of another house in Redfern during 1889. The exact location is unknown. The family also lived in Glebe at one stage, and while there, neighbours had often heard crying from children who were supposedly in their care. A foul odour was detected on one occasion, though John Makin explained to a man who lived nearby that he had buried a little dog the other day, and I expect the fowls have been scraping up the earth about it. This suggests they had started baby farming earlier than known at the time. It begs the question, were there other children who died by the Makins' hands whose remains were undiscovered? The simple answer is we'll never know. Despite the setbacks mentioned, the police persisted with their work, and on the 9th of November 1892, their efforts paid off with the discovery of 4 more bodies at a property on George Street, Redfern. Their work also led to the recovery of another corpse at Alderson Street, Redfern, following which 2 more were found at a house on Levy Street, Chippendale. The house, which was situated near the Appin Hotel, can be seen in this picture. Sarah and John were brought to trial before Justice Sir Matthew Henry Stephen at the Central Criminal Court on the 6th of March 1893. Both were charged with the murder of Horace Amber Murray at Redfern on the 29th of June 1892. The couple entered a plea of not guilty of the charges and were defended by Thomas Williamson. Over the course of the day, Sarah covered her face with a handkerchief, while John sat in the dock, his legs crossed and arms folded as the Crown prosecutor addressed the court and the witnesses gave their evidence. One of the witnesses called was Amber Murray, a young woman of just 18. She was the mother of Horace Amber Murray. Amber Murray was able to identify the clothes her son had been wearing at the time his remains were recovered. One was a gown she had made, while the other was a shirt which had been given to her for him to wear. He had worn them on the day he was handed over to the Makins. Edward Jordan was another witness called to the stand by the prosecution. A horse trainer, he had been locked up with John Makin at Newtown Police Station. Jordan claimed that during their incarceration, Makin had confessed to the murder of an 8th child at the Burren Street house, in addition to the 7 already discovered. He also alleged that Makin had said discovery of the 8th child would mean he would never see daylight anymore. That was what a man got for obliging people. Further, Jordan stated that Makin had said no doctor could prove that he had poisoned any of the children because he never went near a chemist. Naturally, Senior Constable Joyce felt keen to investigate this claim, and on a day of bad weather, he and Constable Alexander Brown donned plain clothes and made their way back to Burren Street. Armed with shovels, the two spent over an hour digging around, though no remains were found. Undeterred, the officers went to the Levy Street house in Chippendale, where after another half an hour's digging, the severely decayed remains of 2 more infants were discovered at a depth of 2 feet underground, close to the wall of the kitchen. The Makins also spoke at the inquest, as did their daughter Clarice. All had testified at an earlier inquest into the Burren Street deaths, held on the 16th of December 1892. On March the 8th, 1893, the trial's 3rd day, the Crown, led by Prosecutor Patrick Healy, finished stating its case. No evidence was given by the prisoners on this day, nor were any witnesses called. Thomas Williamson, acting for the Makins, didn't give in. Turning to address the jurors, he claimed the prosecution had provided no evidence to support the murder charges, that no murder had been committed, and no cause of death for any of the infants had been submitted. Crown Prosecutor Patrick Healy, while admitting the case was a very extraordinary and a unique one, felt the jurors would have no difficulty in finding the Makins guilty. The jury left the courtroom at 5 p.m. to consider its verdict. Just over 4 hours passed before a discussion between the judge and the foreman of the jury made it clear a verdict likely wouldn't be reached that night. For this reason, that night the jury was locked up. The trial recommenced on the 9th of March 1893. On returning to the court, Healy was vindicated when the jury returned a guilty verdict for both offenders. Interestingly, the jurors forcefully recommended that Sarah Makin receive mercy, a fact mentioned by the foreman. Subsequent appeals by the Makins, lobbying by John's brothers, his sister-in-law, and the members of Parliament for the Illawarra, Archibald Campbell and John Nicholson, amounted to nothing. His brothers, sister-in-law, and the 2 MPs presented a petition signed by a collection of Wollongong locals to George Dibbs, Colonial Secretary of New South Wales. Dibbs reminded them that the government couldn't intervene in the case unless other information relevant to the case came to light. Dibbs promised to hold a meeting of the Executive Council where the matter would be discussed. The petition failed to persuade the council, which concluded the law should take its course. John Makin was hanged on Tuesday the 15th of August 1893 at 9 a.m. at Darlinghurst Jail. Pictured. On the Thursday before, he met with Sarah before her transfer to Bathurst Jail. That day, his brothers Daniel and Joseph Makin visited him, as did daughters Blanche and Florence, as well as Minnie Helby, his stepdaughter. He left behind 2 written statements. In one he denied his guilt, the other was an affectionate letter to his children. Sarah Makin had a different fate. After spending time in prison at Darlinghurst, then Bathurst, then Darlinghurst, Bathurst, and finally the State Reformatory for Women at Long Bay, she was freed due to deteriorating health and increasing age after petitioning from Florence and Minnie. Her release came in 1911 when, aged 66, Makin left the Long Bay Reformatory for Women into the care of Florence Anderson, formerly Makin, and her husband. Eventually, she moved to Belgrave Street, Petersham, pictured where Minnie Helby, her eldest daughter, resided. Florence and her husband moved in as Sarah's health continued declining. On the 13th of September 1918, Sarah Makin died, aged 72. Makin's daughter Minnie had died of bowel cancer over 6 years earlier in February 1912. Minnie's husband Carl continued living in the house on Belgrave Street until 1923. At the time, a law regulating baby farming/adoption already existed in New South Wales. Called the Children's Protection Act, it had passed on the 31st of March 1892, before the Makins' actions became public knowledge. Unfortunately, the law proved to be mostly ineffective at its intended purpose, as the Makins' crimes tragically proved. The impact of the case on state laws within New South Wales was restricted to requiring premises belonging to people interested in providing childcare to be inspected and licensed. It also prompted calls for the registration of all childbirths. Where the case had a much wider effect was on British common law, as discussed below. During the trial, Justice Stephen allowed the Crown case to use propensity or similar fact evidence, specifically the evidence of the discovery of bodies other than that of Horace Amber Murray. Stephen justified his decision to allow this by citing the authority of common sense, as opposed to referring to any legal authority which existed at the time. It was in this area that the case had an impact on British common law, which subsequently incorporated the principle of the evidence of a defendant's other criminal misconduct could be relevant. This was included after the Privy Council had backed the decision made under the previous appeal made by the Makins to the Council during March 1893. Interestingly, author and legal scholar Annie Cossins argues in a 2012 piece that the use of legal fictions ended with the couple's wrongful conviction. Cossins states that the New South Wales Supreme Court judges overseeing the couple's appeal ignored a mistake made by the jury and reached what she describes as a finding of fact that Baby D was Horace Amber Murray that they were not entitled to make. Cossins asserts that the celebrated formulation of the Privy Council was founded on a defence that was legal fiction and, in her own words, an unlawful finding of fact. Her 2012 paper can be found in the description underneath. While the legal consequences of this case were far-reaching, the fact remains that 15 babies tragically died. It's a bloody yet forgotten chapter of Sydney's history which deserves to be remembered. Thanks for watching this video, which I hope you found interesting and educational. Work will soon commence on episode 4, so watch this space.